This is LXBN TV, and I'm Colin O'Keefe. A recent lawsuit coming out of the 7th Circuit Court of Appeals between a grocery store chain and Michael Jordan is testing the boundaries of commercial speech. Joining me now from Milwaukee to explain what happened and what other businesses can learn from it is Kellen Kasper. He's an attorney with Foley Lardner, and he is an author on the firm's blog, Wisconsin Appellate Law. Kellen, first, can you explain the basics of the case and how the 7th Circuit arrived at its ruling?
Morning, Colin. Sure. This case arose in 2009 when, to absolutely no one's surprise, the NBA Hall of Fame announced that Michael Jordan would be inducted that year. At that time, Sports Illustrated decided to put together a commemorative issue, a special one just for this occasion, and asked Jewel Food Stores, which is a chain of somewhere north of 100 grocery stores in the Chicagoland area, if they'd like to put together an ad of sorts to include in that in exchange for agreeing to stock the magazine on its shelves. The ad that Jewel ran was pretty simple. It included just really three features. One was a large image of number 23 basketball sneakers, a clear reference to Michael Jordan, and then the Jewel Osco logo and its slogan, "Good things are just around the corner," as well as a short paragraph congratulating Jordan on his accomplishments and saying that it was honoring a fellow Chicagoan who was just around the corner for so many years. In response to that, Jordan did not take well to the congratulations. He filed suit on several grounds, including the Federal Lanham Act, essentially saying this was kind of a false or misleading endorsement, as well as the Illinois State Right of Publicity Statute and a couple other Illinois statutory and common law claims. Jewel right away raised an affirmative defense, saying under the First Amendment, saying that that was essentially a blanket immunity to all these claims. And after discovery, filed a summary judgment motion, saying again, this is fully protected commercial speech. You can't bring these claims against us. Jordan, unsurprisingly, responded saying, this is clearly commercial speech, not non-commercial speech. You're Jewel. You're trying to benefit from associating yourself with me. Look, that's not a defense at all. And just so the viewers know, commercial speech is generally defined as speech that proposes a commercial transaction, which sounds basic enough. The district court agreed with Jewel, saying that, look, there's no reference to a specific product or service of Jewel that they're trying to hawk here on top of Jordan, and it said these claims can't go forward. Jordan appealed that to the 7th Circuit, noting that, look, we think you're wrong. 7th Circuit, put these guys in line. 7th Circuit did reverse, saying that commercial speech is broader than just things that are referring to specific products or services. Even where there are kind of public issues involved, like Jordan being inducted into the Hall of Fame, just because you kind of leave aside your individual products doesn't mean that you have free reign to do this kind of thing. They stressed, first of all, that these kind of brand advertising, just referencing Jewel Osco generally and not what kind of steaks or other products it's selling, that's still just as commercial as things that talk about your individual products or services. And they didn't say that specific product or service references were irrelevant here. They just said, look, those are one of three guideposts we've used where there's both commercial and non-commercial elements, along with whether it actually is an advertisement, which they said it was, and also whether there was an economic motivation on Jewel's behalf, which, again, they also found there was. It really boiled down to kind of this common sense, almost an I know it when I see it kind of thing. Not that, I want to ascribe that to the 7th Circuit, but look, what's really going on here? Are you trying to benefit from associating yourself with Jordan or not? And it's pretty clear the 7th Circuit didn't have much trouble saying that, of course you are. You're trying to promote the goodwill of Jewel by jumping on the back of Jordan and getting the goodwill of Bulls fans in the Chicago area and sports fans generally. And it's good and well for you to try to congratulate him, but you're going to go over the line if it's pretty clear that you're trying to intertwine yourself with it. And I think the problem that I think Jewel really couldn't get around was this incorporating in the paragraph, congratulating Jordan, saying you were just around the corner. Aren't we good Chicago cohorts here and all that? So the court was clearly concerned as far as not letting these athletes and celebrities kind of lose their right to control their identities and likenesses by these kind of, trying to be able to cute by half ads, so to speak, in these kind of commemorative issues and in other contexts. So the upshot was that the 7th Circuit said the claims could go forward. They didn't get to the merits, obviously, because this was at summary judgment stage, so they sent it back down. saying that Jordan's claims could go forward and that the merits were to be considered there.
I see. So, second, speaking in a bit of a broader context here, what issues should businesses and brands be aware of when it comes to showing support in this manner for sports teams and athletes?
Yeah, well, the boundary is going to be pretty fact specific and kind of who you're dealing with specific, so to speak. But what businesses have to remember at all times is that athletes and other celebrities, their images, likenesses, and identities have value. And if you're going to, try to somehow benefit from that without paying them, the courts are going to take a good look at it, and it's not just going to be on the merits of claims like things like the right of publicity claims, but also in discussing the First Amendment implications of those kind of suits. And I guess specifically here, obviously, businesses have to take a close look at these commemorative issues, and I came across one from 2008 last night from Brett Favre when he was still in the good graces of people around here. When you can't just run into this group and join the chorus of congratulations, as the court called it, without thinking whether and how this is a good idea for our business to do. You just have to be careful and not try to get away with benefiting from the goodwill that an athlete or other celebrity has built up for themselves and try to use that to your advantage without paying for it.
Certainly. There are a lot of legal issues to be aware of, and companies should assume that other people will be aware of the fact that there might be some ulterior motives at play when they show support like this. Once again, that was attorney Kellen Kasper. He's with Foley Lardner. For more of his insight on this case, be sure to visit wiappellatelaw.com. Thank you for joining me today, Kellen.
Thank you, Colin.